All right, let's get right into it. We're talking about the Courts Reform Scotland Act of 2014. Now, you need to understand, this wasn't just some little tweak to the system. No, this was the biggest overhaul of Scotland's civil justice system in a generation. And for personal injury claims, it completely changed the game. So, what do you do when the very system designed to deliver justice becomes a huge, slow, expensive machine? Well, that's exactly the problem Scotland's civil courts were up against before 2014. The whole thing was just clogged up, the costs were getting out of control, and for a normal person, trying to get justice felt like a long, frustrating, and incredibly pricey nightmare. So, how on earth did they fix it? To really get why the solution was so radical, you first have to understand just how bad the problem was. By the early 2000s, the official description was that the system was under considerable strain. And that's putting it mildly. It was pretty clear that some massive changes were needed to drag it into the 21st century. This right here, this breaks down the big issues that a major report, the Gill Review, found back in 2009. And you can see it wasn't just one thing. It was a total system meltdown. You had cases dragging on forever, legal bills that were way out of proportion to what people were actually claiming, and just a completely inefficient structure. Basically, it got so expensive and slow that it was stopping people from even bothering to seek justice in the first place. And this gets to one of the biggest logjams in the entire system. You had the Court of Session, that's Scotland's top civil court, getting absolutely swamped with routine, everyday personal injury cases. Think about it. It's like an ER being filled with people who just need a Band-Aid. It was a massive waste of time and resources that should have been focused on the really complex, high-stakes legal battles. So what was the fix? Well, here it is. The Courts Reform Scotland Act 2014. This was the big one. It was a massive piece of legislation designed to go after every single one of those problems we just talked about, taking its cues directly from that critical Gill Review. And, this wasn't some snap decision. It was a really deliberate, careful process. As you can see, it started in 2009 with that review that just laid all the problems bare. Then, in 2014, the Act was passed, giving the government the power to make the changes. And finally, in 2015, they flipped the switch, and the whole landscape of Scottish justice was completely transformed. Okay, now look at this, because this was one of the single biggest changes. Before the reform, any case worth more than just £5,000 could end up in the super expensive high-level Court of Session. The Act jacked that number up by 20 times, all the way to £100,000. That meant, overnight, the huge majority of personal injury cases had to start in the local, more affordable sheriff courts. That bottleneck we talked about, instantly cleared. But here's the thing. To shuffling cases around wasn't going to be enough. The reform did something truly clever. It created a brand new, dedicated court just for these types of claims. It's called the All Scotland Sheriff Personal Injury Court. And honestly, it was a total game changer. This before and after shot tells the whole story. The old way was a mess. It was totally scattered. You had injury cases being heard in 27 different local courts, often by judges who were generalists. They handled everything from debt to family drama. The new system, it brings all that work into one place in front of specialist judges who live and breathe this stuff. And the advantages here are just massive. I mean, when you have judges who do nothing but personal injury cases all day, every day, they get incredibly good at understanding all the complicated medical reports and how to value claims. That means you get decisions that are way more consistent and predictable. Plus, the whole process just moves faster because the cases are being managed by real experts who know exactly what to do to avoid delays. Changing the structure is great, but you also need to rewrite the rulebook to make it all work. So the Act didn't just move courts around. It brought in smarter, more modern procedures and created a much clearer, more sensible way to handle appeals. This new procedure is all about cutting out the nonsense and getting straight to the point. Right from day one, a clear timetable is locked in. There are set moments when both sides have to show their cards, share expert reports and key evidence. And here's the really smart part. They have to figure out what they actually agree on before they even get to the main hearing. That way, the judge can focus only on what's really being disputed. It's a much more hands-on, managed approach. The reform also totally streamlined the appeals process. Before, if you wanted to appeal a decision from a sheriff's court, you had to go straight to the top, to the highest court. It was like using a sledgehammer to crack a nut, So they created this new middle step, the Sheriff Appeal Court. It's a much more fitting and accessible place for most appeals, and it frees up the Supreme Court to focus on the really huge precedent-setting legal questions. Okay, so let's tie all of this together. We've looked at the old, broken system, the new structures, and the smarter rules. But what does it all actually mean for someone making a claim in Scotland right now? Why should you care? This is the punchline. This is what it's all about. If you're making a claim today, your case is being heard by an expert who gets it. The whole system is built to be faster and to actively stop those long, painful delays. The costs are much more likely to make sense for the value of your claim, and if you need to appeal, there's a sensible, affordable path to do it. It just made the system fairer, faster, and smarter. And this quote just nails it. The 2014 Act isn't some dusty old law sitting on a shelf. It is the living, breathing framework for how every single one of these cases is handled in Scotland right now. If you want to understand the system today, you have to understand this reform. So this all leaves us with one last, really interesting question to chew on. Scotland proved that specialization works wonders for personal injury law. So it makes you wonder, right? Could this model work for other areas of the law? Should there be dedicated courts just for business disputes or construction law, or maybe even intellectual property cases? It's a pretty fascinating thought about where the future of justice could be headed.